quality, and aesthetic characteristics of the city of Raleigh, and the members of the commission represent a varied field of expertise and interest in the quality of design in Raleigh. As there are no administrative alternates today, city project reviews, or committee reports on the agenda, we're going to move straight into other business, and we have one item for today. It's the presentation and training session on quasi-judicial procedures and design alternates. Catherine Hoffman and David York from the City Attorney's Office and Daniel King and Bradley Kimbrell from the Transportation Department are going to be leading our discussion. To begin, I'd like to introduce Catherine Hoffman, Associate City Attorney. So I'm going to hand it over to you, Catherine.
All right, thank you, Brandy. And we'll go ahead and get started. I want to make the most of our time. And I'm here with David York as well in our office. And as we said at your last meeting, I'll be representing you when you have your quasi-judicial evidentiary hearings, and David will also be representing times when I'm not there, so you'll have the both of us as a resource. I want to start, though, by thanking all of you for taking the time, especially on a Friday, to do this. I know it's trainings. We're going to try to make this as fun as possible, and I want it to be interactive as well. I just think it's very important that we do this before you start hearing quasi-judicial matters. So I really appreciate you guys taking the time to do this. And this is being recorded. So those who are missing it, or if you don't pick up everything, other quasi-judicial boards, we might have them watch this part too. So, okay. So as you know, let me start really quickly. We have a little notebook we put together with reference materials for you. It has your rules of procedure, all the applicable statutes and UDO provisions. We try to put those in the mail to each of you before this training so that you could receive them. If you do not receive it in the mail, then you can go onto Board Docs, the agenda materials, and it's posted there as well. And this notebook is going to kind of guide us through this training, but it's also a reference manual for you to keep going forward. There's some things, and I'll kind of explain, that I think would be helpful to have in front of you every time you hear a quasi-judicial case. So as you know, you now have a new function, which is this quasi-judicial body. And the purpose of today's training is twofold. The first hour, I'm going to give you the legal rundown of how a quasi-judicial body works. And then the second hour, transportation is going to get you familiar with the UDO provisions that are going to be at play, that you're going to be asked to be granting design alternates from. So I'm going to tell you really quickly, there's about 4 or 5 legal topics I need to hit in my first hour, but if you let me talk about quasi-judicial for an hour, I will definitely do that. So please feel free to interrupt me and ask questions. I really encourage questions. So I need to go over with you quickly just your overview of the Appearance Commission, the overview of a quasi-judicial body, how a quasi-judicial decision is made, and also briefly talk about appeals of quasi-judicial decisions, and then have a few miscellaneous topics if we get to them, which are your bylaws, your ETJ rep, and also how we're doing special procedures for remote quasi-judicial. So if you look, starting kind of with stepping back, the broad overview of what is your board now that you have this new function, what do you look like? And if you look in the notebook I gave, the first tab is a little overview of Appearance Commission. So you kind of have 2 hats now. Your first hat is what you've been doing up until now, which I don't know if you are familiar with the statutes, but you are governed by statutes when you act as an Appearance Commission. So your first hat is as an advisory board, you do everything that you do now. And that's actually under state law called a Community Appearance Commission. Here we call it the Raleigh Appearance Commission. It's governed by General Statute 160D-960. I've given you a copy of that to read in your free time. Your new hat is a quasi-judicial body. And the way we're doing this is it's a little bit funky. The general statutes say that City Council, a planning board, and a board of adjustment can hear in a quasi-judicial capacity requests to alter UDO provisions. What you are doing when you hear quasi-judicial matters is you are actually performing the functions of the planning board. And I've kind of given you the little statutory guide if you wanted to look and see how we got there. But What you need to know is that you're acting in a quasi-judicial capacity, performing the functions of the planning board, which is allowed under state law. So with that kind of overview, you have your two hats. My understanding from talking with Carter and staff is that the plan right now is for you to hear, and also this will be dictated by how much caseload comes in, but the plan is to hear quasi-judicial at one meeting and your advisory and everything else at the other meeting. As you'll kind of hear as we go through, it's a little hard to switch hats midstream during a meeting. So we thought that would be helpful for you all, but we can get feedback on that too as we go forward. Okay, so what is a quasi-judicial body? Like a little mini court. You conduct evidentiary hearings on each request, and there are certain due process procedures that you have to follow. And I've listed for you, I've given you kind of a little bit of a definition of a quasi-judicial decision. And it's when you have a set of discretionary standards and you're applying discretion as to some degree of discretion as to whether the evidence presented meets those standards to be granted the request or the alternate they're asking for. So you have to comply with certain due process procedures when you are acting as a quasi-judicial body. These are listed on page 2 of, if you ever want to reference it, of the little handout I gave you. So you have to have sworn testimony. So at the start of the hearing, everybody's sworn in by the chair. Parties have the right to cross-examine witnesses, which means that sometimes, typically you have just an applicant, but sometimes you'll have neighbors who appear, and sometimes you'll have experts as well, which I'll talk about here in a second. So all parties have the right to cross-examine those witnesses. They also have the right to inspect documents as well, and you have the right to submit documents in support of your case. And then the decision has to be a written decision with findings of fact and conclusions of law. So the way an evidentiary hearing is supposed to work is you walk in without any knowledge besides the staff report that's given to you before. You want to walk in almost with a clean slate, and you're supposed to make your decision based off of the evidence and testimony that are presented at the hearing. So because of that, one of the biggest things, it's when a body goes from doing non-quasi-judicial to quasi-judicial, one of the biggest things I tell them is that due process requires no ex parte communication. I don't know if applicants contact you now with admin alternates or not, but one of the biggest things is that you can't talk to anybody, including each other, outside of the evidentiary hearing about the case. Again, the idea being everybody gets a fair shot at presenting their case at the hearing, and there's no outside undisclosed communication. A common thing, people usually ask, well, what happens if I see somebody at a grocery store or, they're a friend of mine, they start talking to me about the case. The appropriate thing to do would be to tell them you can't talk about the case outside the hearing. And we'll talk about conflicts of interest here in a minute. If it kind of goes a little bit further than just, I'm having a case before you, then there's a way you can disclose that communication, which we'll talk about here in just a second. So there are 15 members of you on the Appearance Commission. Under state law, a majority of the membership of the commission is required to vote in favor of an applicant for them to be granted a design alternate. So for you all, that means that a minimum of 8 appearance commissions must rule in favor of the applicant. Something we routinely do at the Board of Adjustment, they have a provision where they have to have 4 out of the 5 members vote in favor. I don't know how often there's only 8 of you at the meeting, but something you might want to think about is giving applicants a heads up when that occurs. There's only 8 of you, that it would take all of you to vote in their favor. And again, I don't know how often that happens, and we can address it as it comes up. But keep that 8 number in your head. And then the other thing, which we'll talk about at the end, is that your decisions are appealable to Superior Court. And we'll talk about that a little bit. So I'll take a quick break here if there's any questions before I move on to the next part. Feel free to ask any question. Okay.
Catherine, you may cover this later, but how often are cases deferred if we want to hear more more information about a case, can we defer it to another one? And then if we can, I assume we're not supposed to talk to each other about it in the meantime.
You're correct. If it is deferred, you're not supposed to talk to one another. Here's how it normally works: is the applicant, you can tell them that you don't have the information if there's something that you're missing in order to vote in their favor. And if it's looking like it's not going to go in their favor, you can let the applicant know. You can either vote on it, or you can, it's really kind of the applicant's request to continue the case so they can come back with more information. It doesn't happen very often. Typically with quasi-judicial procedures, and this is something I can go ahead and talk about now, is that it's considered the unauthorized practice of law for anybody besides the property owner to represent a property owner. So typically you're going to have attorneys at these hearings, and they're going to be geared up if, they're going to have their evidence that they need to present, and they're supposed to have their evidence towards the standards. And so it's rare that you have to continue a case. But when it comes up, we'll be at the table with you, and it's kind of usually the applicant's choice. And so let me talk about that unauthorized practice of law just a little bit more. So the North Carolina State Bar has issued an opinion that says it is considered the practice of law, it's a legal proceeding, and it's considered the practice of law to appear on behalf of another person at the evidentiary hearing. So a property owner who is an individual can always appear and represent his or herself. If the property is owned by a corporation, state law says that no individual that's not an attorney can represent that corporation. So we usually do a check on the front end when we get the applications in to see who's the applicant and who's the property owner, and let them know beforehand if they are not allowed to represent the property owner, that they have to get an attorney. The other thing that will come up, and I'm not sure how much this might come up at appearance commission, but sometimes an architect or an engineer or a realtor may come in and try to represent a neighborhood as a whole, or represent a property owner who's a neighbor. And they also are not allowed to appear on behalf of somebody else if they're not an attorney. So those are things that our office will help you with during the meeting, and we'll try to prevent before the meeting as well. But that's just something you should keep in mind as well. The other thing, really quickly, is about experts. So under state law, your decision must be based on the material, substantial, and competent evidence that is submitted at the hearing. Material means relevancy. So the evidence being submitted is relevant to the standard that you have under consideration. Substantial means that they give you enough information to answer the question or to show the standard has been met. Competency talks about experts. So the person who's testifying has to be competent to testify to what they're speaking towards. Under state law, there are 3 situations where an expert is required in order to testify towards a matter. And that has to do with traffic, typically stormwater, and property values. So if one of your standards has to do with traffic safety, then only an expert in traffic engineer, for example, is considered competent under state law to testify to that standard. Same with property values. So sometimes you'll see a standard that says in quasi-judicial, you won't adversely impact the value of surrounding houses. I don't think you have any of those standards today, but when you do, only an expert in real estate appraiser, for example, could testify as to that matter. So, and the way it works, there's a new case that came out recently. It's actually a case that Robin and I worked on from the city of Asheville. The law is that if a witness shows up and has an expert that produces the competent material, substantial evidence as to traffic safety, for example, then in order to dispute that evidence, they've met their burden. In order to dispute that evidence, you then have to have on the other side an expert as well. A lot of times you'll get somebody that will come up and say, that's not an expert who lives in the neighborhood, and try to ask questions, and that's fine. But just remember that if you have an expert that meets what's called the prima facie burden, then typically you have to have an expert on the other side to kind of rebut that. So, and again, this doesn't happen often. I'm just kind of giving you an overview of several legal topics that might come up. And when that happens, our office will be there to help you. Okay, so the next thing, you guys flip to the second tab in your notebook. I've given you a little cheat sheet on conflicts of interest. So the standard, when you act as your advisory board, so the way you act now, under state law, the only conflict of interest that you are required to recognize is when you have a direct financial impact in the outcome of the matter. When you're acting in an advisory capacity, it's probably rare that that happens, but that's your standard now as an appointed board. When you're acting as a quasi-judicial body, the standard's a little bit higher. The overarching principle to remember is that you can't, everybody is entitled to have their due process, a fair quasi-judicial evidentiary hearing. So you have to be able to be a fair and unbiased decision maker. So you can't violate any person's constitutional right to have an impartial decision maker. That's your overarching principle. And then state law defines 4 times when that are considered impermissible violations of due process. The first one is having a fixed opinion prior to the hearing that is not susceptible to change. That's rare. And I've seen that come up when boards, well, I don't know if we have enough time to go into that, but that's a rare one. The second one is what we talked on earlier, which is undisclosed ex parte communication. So that's if somebody stops you at the grocery store and says, "Hey, I have a case coming up before you," and say, "No, don't talk to me anymore about it." And they go on and talk to you about their, the merits of the case and their conversations with the neighbors, and try to kind of tell you, "Hey, vote in my favor." What you're supposed to do under state law is disclose that communication at the start of the hearing. And I'll talk to you in just a second about how to do that. The third conflict of interest is having a close familial, business, or associational relationship with an affected person. That's probably going to come up the most, and state law defines what that means. And I'll discuss that here in just a second too. And the fourth one is obvious, a financial interest in the outcome of the matter. That's the same conflict that applies no matter what you're doing. So those are the 4, those aren't the only 4 that can be a violation of due process, but those are the 4 that are recognized by statute. Statute does not define what is a business or associational relationship with an affected person, but it does define the family relationship, and it's pretty broad. I've given you the definition. It's spouse, parent, child, brother, sister, grandparent, grandchild, including step, half, and in-laws. So anybody that you might be related to within your immediate family is going to be considered obviously a family relationship. Now, here's what you need to do if you think you have one of these conflicts. The first thing to do is to disclose it at the start of the meeting. Then the question is, you need to state for the record whether or not you think you can be a fair and impartial decision maker. So if you have a business or associational relationship with an affected person, you have to recuse yourself. But if you have, let's say, undisclosed ex parte communication, you disclose it, then it's not necessarily a conflict of interest for you to hear the matter. If there is a question or an objection to whether or not you can participate in the matter, then the board's supposed to vote on whether or not to have you participate. So what I recommend doing is, if you're looking through your case materials and you see something that's clearly a conflict of interest, then make sure that you raise it and recuse yourself at the start of the meeting. If you have a question about whether it's a conflict of interest, you can always contact me before the meeting and get my opinion, and I can help you either before or at the meeting. But it's always good to kind of give a heads up if it's something we need to look into. So the other thing I would note is that I would make sure when you recuse yourself to state why, so for the record. And I keep saying for the record, and let me tell you why I'm saying that, because everything you do in a quasi-judicial evidentiary hearing is you're creating a record. So the testimony, the exhibits, the application, all of this is actually put into what's considered a record. And when we talk about appeals of your decisions, that record is what gets transferred to the Superior Court. And the review of your case is called an on-the-record review. So they review the record. They don't hold a whole new hearing again. And we'll talk about that a little bit more here towards the end. But just keep that in mind, too, is that you're building, you and the applicants and participants are building a record that will be reviewed on appeal.
Catherine, can I ask a quick question?
Sure.
Just to be clear about when we recuse ourselves, it's at the beginning of the entire meeting, not at the beginning of the presentation of that case?
It's at the beginning of that case. So
Okay.
what I would do is when the case is called, before the presentation starts, that would be a good time to raise your hand and say, I need to be recused because, this is my brother-in-law.
Okay. Thanks.
And
Yeah, we need
then,
to handle that before you hear anything.
Sorry.
and then
That was Adam Walters asking that question. Is that correct?
That's correct.
Just you're not on camera, so you need to identify yourself before you speak. That's one of the hassles of turning your camera off. Just wanted to clarify for the record.
hey,
Catherine, this is
and
this is
the
William
virtual. Go ahead, William.
Sorry, I just had a question. So you were saying eight members for sure have, in order to have a decision, you have to have 8 members, regardless how many people are there, correct?
Correct.
Okay. So my concern is rarely, if ever, have there ever been all of us there at one time, and also too, since we're all architects, a lot of us are architects, landscape architects, civil engineers, etc. There is a high likelihood that 2 or 3 or 4 of us could be working on a project together that we would need to recuse ourselves of.
Let me get you, and the statute covers that. Let me pull it up for you real quick. 160D 406 is, and all these statutes, I've given you copies of them. I've probably given you copies of every statute above and beyond what you need. But here's what the statute says. That for purposes of counting, let's say vacant positions on the board and members who are disqualified for voting because of conflict of interest
Cool.
shall not be considered members of the board for calculating the requisite majority. If there are no qualified alternates available to take the place of such members. And I believe you guys don't have any alternates. So great question. And I'm glad you brought that up, so I know that that's something that might become a common issue.
Yeah, I guess I was just thinking, like, if there's 16 of us, but only 11 of us are there, and Chris, Adam, I, and somebody else are working on a project together, and then all of a sudden we have to recuse ourselves. We don't have 8 people that could meet that majority.
Yeah, and what we would do is then I could run the math for you and tell you what we would do is start off with your 15 or 16. How many members? Okay, if you start off with your 15 members, let's say 2 of you have to be recused because of conflict of interest. So then you just assume your number's down to 13. And then you have to have a majority of 13.
Yeah.
So,
yeah, I just wanted to mention it because I think it's something that we could run into potentially. I think it's just makes it even more important that everybody's at every meeting.
Hey, Catherine, in the virtual environment, when someone recuses themselves, do they need to, turn off their screen, mute? Like, what's the?
Good question. So what I think is that you're recusing because you're not voting on the matter, and you're also not speaking or influencing the matter, I guess, as the board member. So I think if you turn off your camera and and mute yourself for that one matter, I think that's fine. I don't think you have to log out of WebEx or anything. I see it no differently as you recusing yourself and sometimes even still sitting at the table or sitting in the audience. I think that's fine.
Catherine, hey, Jamie Ferguson, with what William was talking about, if we do find ourselves with an even number, who then is the tiebreaker?
Well, if you have an even number, it requires the majority of the membership to vote in favor. So an even number would not, the vote would not pass.
Okay, thank you.
All right, it's a good place to pause if there's any more questions before I move on to the next little phase here. Good, okay. The next thing I kind of want to switch to is your decisions, a quasi-judicial decision. So if you look in the notebook I gave you, tab number 4 is a sample decision. This is actually a decision from a recent case that I did at the Board of Adjustment where the city was seeking a number of design adjustments as well as variances in order to build a new fire station off of Durant Road. So the reason why a decision is quasi-judicial under state law, kind of back up for a second. Under state law, city staff members can administratively apply objective standards in the UDO. The majority of zoning standards are objective. Do you meet building height? Do you meet setback? Do you, are you having the right use located in that district? Typically, the staff just applies. It's almost like they check and confirm that the proposal meets the UDO. If there are any discretionary standards, though, when it comes to zoning ordinances, so, for example, this is how design alternates came to use, because previously the code said that city staff could, in their discretion, grant a design alternate if, and it had some standards, and those standards were also subjective. What state law says very clearly is that if you have any discretionary standards in the UDO or any zoning decisions that are discretionary, those decisions have to be made by a quasi-judicial body performing all of these quasi-judicial due process functions that we've been discussing. So what you're being asked to do when you have a quasi-judicial decision is you have subjective standards. So if you look, before we get to this decision, actually, if you look in your packet at the 3rd tab, I've given you the discretionary standards that you're going to be asked to review. You're going to be asked to look into UDO Article 3, which I don't want to interfere. Transportation is going to go through all this in detail with you in the next hour. But just high level, you're going to be looking at UDO Article 3, which governs lots, blocks, and access. UDO Article 4, which governs new streets. UDO Article 5, which governs existing streets. Might have got those backwards. And as well as the Raleigh Street Design Manual. So when you are looking at requests for design alternates from those standards, the UDO has a list of the discretionary standards you're required to consider. So if you look under the tab 3, there's 2 sets of standards. One set applies to request for design alternates from Article 3. 8.3. And there's a list of 4 standards there. The second set of standards applies to everything else. So Article 8.4, 8.5, and the street manual. And there's a set of 6 standards there. I've given you these little cheat sheets because I highly, highly recommend every time you have a case before you that you have these sheets in front of you. Because what you're asking is yourself is whether the competent material and substantial evidence that is presented at the evidentiary hearing meets each one of these standards. I think that this is something that just in watching your meetings that you're familiar with right now anyway. I know you guys have some standards, and I've noticed you routinely at the end of the case go through, I think Brandy says, okay, standard 1, standard 2, you guys go through each one. And I think that's a great practice. And I think it's a great practice to carry over to quasi-judicial because that's really your charge is whether the evidence, and I've given you the little lead-in language, whether the, again, competent material, substantial evidence submitted shows each of these findings. Now, the way the decision has to be created is that your first question is whether or not that evidence, you create what's called findings of fact. And you have to have findings of fact to support each one of these standards. You then have to say, okay, based on those findings of fact, as a conclusion of law, I conclude that they meet the standards to be granted a design alternate. The way, and again, this all goes back to the record and the evidence submitted. And if you flip back to the decision, the draft decision here that I gave you, this was an approval of several design alternates. And if you look at the way it's structured, you'll see the findings of fact. And in this one, there were numerous requests. So there's a lot of findings of fact. And if you get through all of those, at the end, you'll see the conclusions of law. And so those findings of fact, you have somebody in there to address every one of those standards to show that as a conclusion of law, the applicants met their burden. These decisions will be drafted by our office. And this is kind of jumping a little bit ahead, but the way it's going to work is at the meeting itself, you vote to approve or deny. Following the meeting under state law, your decision has to be reduced to writing. So what our office does for you is drafts these findings and conclusions. We have draft ones for your consideration. They are then incorporated into the draft meeting minutes. And so you'll get a copy of that before the meeting. What will happen is after each case, there will be a little sentence in the minutes that says the board's decision with findings of fact and conclusions of law are attached here too, incorporated herein. And then when you approve the minutes, you're approving those written decisions as well. Following that adoption, the board's chair has to sign the decisions. And the way we're doing that with COVID is that we have a remote way to send them to you for a signature. And then it has to be filed with the city clerk. And Ralph Puccini, who I don't think is on this call, is going to be the assistant city clerk, is going to be the clerk for your quasi-judicial evidentiary hearings. Now, once all of that is done, then under state law, your decision becomes effective. The consequence of that effective title is that it then becomes appealable. So under state law, once it becomes effective, it has to be served, and staff handles all of this side of it. But just so you know, it has to be served on the property owner, the applicant, and anybody who requested a copy of the decision before it becomes effective. And what we do is we either typically we email, we might stick it in the mail. And once they receive it, then they have 30 days from receipt in order to appeal that to Superior Court. When you receive a copy of the decision, that's considered actual notice. Now, neighbors, for example, let's say they don't request a copy of the decision, they can appeal when they have constructive notice or actual notice. But sometimes, and this is all very fact specific and probably way more than you need to know, but the point is that sometimes constructive notice is not immediately after it's mailed to the property owners. Sometimes it's when the property starts to be developed and they can see it on the ground. So 30 days is typically after 30 days, this decision cannot be appealed. But there are some instances where it's a little bit longer because of constructive notice. So I'll kind of jump forward here to appeals. If the decision is not timely appealed, it cannot be challenged after that. If it is timely appealed, the way it works is that the court takes the record and they review, they don't have a hearing again, they look at the record and they look to see whether the decision you made was supported by the record. And this is where those written decisions come in handy. If the court finds that the decision you made is supported by the record, then they approve it. They don't have discretion to say, well, I would have voted otherwise, or I would have done something differently. All they're looking at is that whether the evidence presented supports your findings of fact, and your findings of fact supported your conclusions of law. Now, there are some other legal technical things that the court can look at outside of the record, but it's based on when there's questions of law. But for the most part, what you need to keep in mind is that, again, you're building a record. Your decisions have to be based on the evidence submitted, supported by the evidence submitted, and then we'll help draft those decisions. And so on appeal, that's what the court is looking at. Does anybody have any questions? I'll kind of take a little quick break here. Okay, no questions? Okay, so if you get some free time, and another thing too is that as you do a couple of these, you'll start to kind of understand a little bit more about, start to see some patterns. about testimony and circumstances and evidence that meets the standard. And you'll start to see kind of, there will all be different fact patterns, but you'll see kind of a theme or some similar trends in the types of requests and the reasons for the requests that you hear. And I'll let Bradley and Daniel kind of go into that a little bit more. Okay, I have a few miscellaneous items that I want to talk about as well. The first is your bylaws. I have given you the statute 160D 308 that talks about what they call them rules of procedure. It's the same thing. That talks about your rules of procedure and gives you the authority to create them. Your bylaws obviously have not been updated to reflect your new quasi-judicial role. You have a conflict of interest standard in here. I know you have a committee that maybe we should talk about this a little bit. A committee, I believe, that looks at certain requests beforehand, which, as we've discussed with quasi-judicial, you have to do that at a quasi-judicial hearing. You can't discuss before the hearing. But I've given you a copy of your bylaws and just wanted to kind of give you a heads up that our office is going to work on drafting maybe a red line version of to amend your bylaws to be consistent with your new quasi-judicial function, to add that information in there. So I think what we'll probably do is get a red line version, and then once it's ready, get it on one of your agendas. And so you can get a copy of it beforehand, and you can look at it and see if you have any edits or questions, and then we can discuss it at one of your meetings. And you can vote then to amend your bylaws. So that's just kind of a heads up that we're looking into those as well. The next little miscellaneous thing, which I believe you already are aware of, is your ETJ rep. So for the first time, when Chapter 160D, which is a new state law that recodified all of the land use and planning statutes in North Carolina, it added in there that appearance commissions are required to have ETJ representation. The new law, check here. It's a little bit funky how the effective date. It's effective now, but it's the law now. But for each individual city, it becomes effective the sooner of two things. Either you amend your ordinance to comply with the new law, so the UDO is amended to require an ETJ rep for the Appearance Commission, or you hit the deadline to do so, which is July 1st, 2021. So the bottom line is you have until July 1 of next year in order to get an ETJ rep on the Appearance Commission. And we're working and staff's working on making that happen. So that's just a heads up of why there is now a necessity for an ETJ rep. And then the last thing I have to talk to you about here are remote quasi-judicial evidentiary hearings. A lot of what you're doing now at the Appearance Commission for these remote meetings is, and maybe everything you're doing now, is the same thing we're doing with Board of Adjustment, which also is the other quasi-judicial board. A couple things that we're doing ahead of time to meet due process are the oath forms. You're probably not doing this now. We're requiring everybody to sign up to participate before the meeting. Also mailing notice to everyone within 100 feet of the subject property, posting notice on site, doing a publication, a web notice. And all of that says that if you would like to participate, you have to sign up in advance. When you sign up to participate, you're emailed in a blank oath form. Because, as we discussed, all testimony has to be sworn testimony. We are asking participants to complete the oath form before the hearing. And then what I've been doing is having the chair reaffirm their oath at the start of the hearing. So that's one new COVID thing we're doing. The other one is we talked about how witnesses and parties have the right to inspect documents. The way we've been handling that is asking all participants to submit their documents ahead of time, and so we can include them in board docs. We're also putting staff's materials, PowerPoints, presentations, staff report in board docs as well ahead of the meeting, so that they can be reviewed by everybody has them before the hearing, And then also at any time during the hearing, if somebody loses the ability to see them on the screen, they can go to board docs and look at them that way. And then the other thing we're doing is obviously the signing up. One thing that that's going to be different for quasi-judicial is that this new remote law that lets us do these hearings says that all parties with standing have to consent to the remote proceeding. So what we are doing is in all the letters we mail out to the surrounding neighbors, and what's standing for quasi-judicial, I can talk on that briefly in just a second. But we're mailing the letters out to everyone in the surrounding neighborhood and with the information about contacting the city if they have any questions or concerns with the remote format. And we're asking parties to state their consent on the record, again, building a record to the remote proceeding. So just really quickly on something on standing, and I don't want to bog you down with too much legal jargon. In quasi-judicial matters, parties are supposed to, well, I guess we'll start with the appeals. You can only appeal a decision if you have standing. Now, who has standing is something that a court looks at and is typically considered on appeal. You don't typically do a standing analysis at the commission itself. It's something that's argued later on appeal. And who has standing is something that's constantly in flux with the courts and their decisions. So typically it's going to be the immediate neighbor. It has to be somebody who has special damages. So it has to be somebody that's impacted by the development, and they're impacted in a way that's different than other members of the community. And those are all things they have to argue at the when they appeal their case. You know, when standing is typically handled on appeal, and it's a common question that's raised to dismiss appeals. So it's a commonly litigated question, but you guys, for the most part, don't need to worry about that at your commission hearings. So let me take a quick break here and see if there's any questions. You good? And I'll ask David too. David, is there anything that I haven't covered so far?
I think you've been very thorough.
I hope so. Maybe that's why the questions covered it all.
Just to be clear, Catherine, this is Adam. Are we going to be filling out these oath forms each time we meet, or is that for the other folks?
Good question. You don't have to do one. They're for the people that are going to be testifying. Okay. So the staff members, and that's another thing too, is that at the beginning of the hearing, everybody's sworn in. And that includes staff members. So whoever's presenting the case, let's say Carter's presenting, Carter will be sworn in because he's a witness. And then all of the applicant, the property owner, anybody who's there to speak on their behalf will be sworn in as well. But you're good.
Okay, thanks.
Yeah.
How about as far as the online, is that part of the kind of opening remarks that we can do, or do we need to do that before each case? Or
so what I've been doing is you have your opening remarks that, and actually I listened to your last meeting, and the remarks you're making now are consistent with what we're doing for Board of Adjustment, which is explaining that this meeting is going to be conducted in accordance with the new state law, the notice procedures, the signing up, all of that. Then what I've been doing is that at the start of each evidentiary hearing, so we kind of hit the reset button each time. So at the start of the hearing, we'll say, okay, we have 3 people sign up to participate. Call their names out and have their oaths reaffirmed for the record before we start the evidentiary hearing. We've been having, for BOA at least, we've been having the staff members all sworn in off the top for all cases, so we don't have to do it each time with each case. And again, this is running a lot. This is not how it would run if we were in person. It's just what we're doing for remote.
And Carter has been awesome and has been preparing scripts for all of these things. So just as you move into the role of introducing all of this, it's not something you have to invent every time. So it takes some pressure off. I do have a question about, not discussing cases before they're heard or outside of the public hearing. I know, for instance, with RHDC, they have a special kind of committee that's formed or made up of sort of Historic Development Commission members, and they're an advisory board. It's called the DRAC board or whatever, and it basically helps applicants understand, kind of what the main concerns that the board is going to have or the commission is going to have, and it kind of helps them work through their presentation so that they have a better chance of being successful. Do you think there's the need for something like that eventually with the Appearance Commission, or do you have any thoughts on that?
That's a great question. So RHGC is a little bit different in that they have their guidelines that are specific to each historic district, and it's looking at exterior kind of design. And so boards of adjustment, which I know you're not a board of adjustment, but you're acting as almost as a board of adjustment, typically don't have those kind of pre-feedback kind of review boards. But as long as it doesn't violate due process, then it's not something that's legally incorrect. But typically I have not seen them with these types of boards or making these types of decisions. And I think the key thing that you said there with RHGC is that it's ex-Appearance Commission members, so that it's not ex parte communication with the decision makers.
That's right.
So, and I think, are you guys, Brandy, maybe you can answer this for me. Now I believe you guys have something similar for admin alternates.
We do. We've always heard them really as just the full commission. So it was a courtesy review. And because we were just making recommendations and not doing findings back, it wasn't quasi-judicial. We could just do that as, a courtesy. And again, I think I don't necessarily understand which pieces of what we're reviewing are going to fall under the quasi-judicial umbrella and what pieces are going to fall under our standard, like what we're used to review umbrella. So at some point, maybe you can kind of give us just a quick breakdown of how that's going to divide out too.
Yeah, and I can kind of do that now. And that's a great segue into the second part too, is everything I've been talking to you about is about how to act as a quasi-judicial board and how to make quasi-judicial decisions. But you're right, we haven't talked yet about what you're actually deciding, which is a very important key piece. And that's kind of our second part of this training. You're going to be hearing transportation-related requests. I'll give you a quick example. There's a requirement that certain driveways be spaced 300 feet apart, a minimum of 300 feet. A common request is to have driveways located closer than the minimum spacing requirement. When an applicant wants to do that, they have to come to your board and you apply the applicable findings and conclusions to go through and to their request. So what you're hearing now in your advisory capacity, you will continue to hear for the time being in your advisory capacity. Nothing's changing for today with what you're hearing right now. Everything that you're going to hear quasi-judicial is going to be new. And Daniel and Bradley are going to give you a complete overview. I'm really amping them up, talking them up, of the transportation UDO provisions and principles at play. That's a great question. I'm sorry, I should have made that more clear at the beginning. The other thing too is we haven't gotten into the nitty gritty of your standard itself. And you can read it. I can read it to you. You can look at it in the tab I've given you. I think I have found, at least when you have discretionary standards, that they're better learned through examples, how to meet the standard. So, I mean, if you read, for example, that for an alternate from 8.3, one of the standards is that it is deemed reasonable due to one or more of the following. And one of those is that given the existing physical environment, compliance is not physically feasible. When you just read the standard without having any context and examples, it's really hard to understand what type of situation meets that standard. So I haven't really gone into the details of those because I think it would be helpful for you to hear from Daniel and Bradley first. But the thing that I just want to keep, if I could legally kind of just emphasize anything else again, it's that your decisions, you're looking at this standard, your decisions are based on the evidence presented at the hearing, and the question for you is whether there has been competent material and substantial evidence to meet every element of the standard. Okay. And again, also one thing that you guys do now that's helpful is when you, at the end, I think, Brandy, when you go through each standard and you ask the board for feedback, that information is also that's part of the record, your statements, and it's helpful for for us when we draft your decisions to know why to hear that feedback from you. So I would encourage you to keep that up as well. The communication about how you think it does or does not meet the standard. And I'd also emphasize again, they have to meet every standard. So if they don't meet one of them, then under state law, then they haven't met their burden.
And staff has been really great, again, to help us substantiate those things, right? They give us a playbook. And so anyway, it's been very helpful. And thank you, Carter and Lee and whoever else is on here who puts all that together, because it makes it easy for us to substantiate the findings. So.
And let me tell you something, too. I'm really glad you brought that up. And this is something that might be different in quasi-judicial, is that you won't hear a staff recommendation.
Right.
So staff won't say, yes, vote in favor or deny this. What you're going to hear is, and transportation is going to be at your meetings as well. And I think they're a good resource and they're considered witnesses as well. If you have a question about, well, what's the intent of this UDO provision? That's one of your standards is here. Is that what they're asking still meets the intent? If you don't know what the intent is, you can definitely ask staff that question. Staff may point out in their staff report or when they speak at the meeting, some additional information that might be relevant to a standard, or point out that the applicant, and to their knowledge, has not given information on X. So they're there as a resource for you, but they're not going to say approve or deny. And I don't know if that's different than what you have if you're getting recommendations now. With admin
We're not. Staff has been very kind to us. So again, they give us lots of information, right, that lets us substantiate the case based on how the commission feels about it. So hopefully that's something that sounds like it's not going to change.
Okay.
Kevin, this is Jake Levitas. I was going to ask, within our packets, just kind of building off the last for each case, currently for our advisory cases, and the text of the intent and the text of the UDO, I believe, or the key sections of it are repeated, laid out for us text in the packet for the case. Is that something that will be included as part of each case for us or are certain things going to change in terms of what's included and what's left out?
So I think that it should be pretty much the same. I don't want to speak for Carter and Travis is here too. I think they might be helpful to answer that question, but I believe that your staff reports will continue to contain the standard as that issue. It should also include the UDO provision at issue. It should also include the standard that applies to that design alternate request. With respect to the intent, I think that sometimes staff puts feedback in the staff report as to the intent. It's an every time thing. But they also are there to give that to you at the meeting. I don't really know if intent is something that's planned to be put in the staff report every time or not.
You're going to be looking at Articles 8. This is David York. You're going to be looking at requests for administrative alternates in Article 8.3, 8.4, and 8.5. Each one of those articles has an intent section at the very beginning that says what the intent of that article is. And so if that's a request, I think staff's report could reflect what the UDO says is the intent of the article, for each case, depending on which articles at play. I don't think this is going to be a heavy lift for the Appearance Commission, because back when we were working on the text changes that created this, I had an opportunity to watch one of your meetings, and I was surprised that you were already doing, except for swearing the witnesses, you are already doing pretty much evidentiary type hearings. And the way you handled your deliberation at the table is very much how quasi-judicial boards, I'll say, are supposed to handle their deliberations where they focus their attention to the findings. I recall one hearing, this is back when y'all were meeting in person, where someone stood up and started to talk, and this is on your administrative alternates, talk about a hardship, and you caution them that we don't look at hardship, focus on the findings. And as soon as that happened, I got out the phone, I texted Catherine, I said, I think we've got our board, because we were looking for who, if not the Board of Adjustment, would handle these types of cases. So I think you guys are going to find it a smoother transition than some of the other commissions would have, because you're already going through sort of the same exercise mentally. And it'll be less, I guess the issues are going to be more technically transportation oriented on these design adjustments, as opposed to blank wall and transparency and what's a good amenity in lieu of a build to and so forth. But those two eventually will probably be converted over to quasi-judicial as well.
And that we have 4 minutes here, and there's something very important I realized I didn't talk about, which are conditions. You have the ability to impose conditions on, if you decide to approve a request, you have the ability to impose with conditions. Now, here's the deal with conditions. If you're familiar, sometimes boards think about with rezoning cases where both the applicant and the city consent and agree to the condition. When you're making quasi-judicial decisions, the applicant doesn't have to agree to it. So that's one thing I'd keep in mind. Sometimes you can ask them if compliance with the condition would be possible for them, but you have the ability to impose conditions. And when you do, the conditions are supposed to be intended to ensure compliance with the standard. So that kind of also gets back to staff's participation and their testimony in the case. There was a case that came up at the Board of Adjustment recently where the question was if the applicant included a condition that, yes, they could have the spacing alternate, but maybe the driveway spacing request, they're closer, but maybe that one driveway, the condition is you only turn out of it. So those are the kind of questions you can ask transportation staff if that would further the intent of the ordinance provision itself, the rule itself. So that's something important to keep in mind. The Board of Adjustment, the past couple months, I believe that they had at least one case they've heard a month that they've imposed a condition on. But just keep in mind, if you're on the fence and there's a condition that would make the request more or in compliance with the standard, then you can impose that. And we're here too to help you with those conditions and to craft the language with your motions.
I think that's
okay. We have 2 minutes before we have to turn over our part. So any questions or anything I didn't cover?
Catherine, could I ask one quick question?
Sure.
So something happens in our current commission hearings that I'm wondering if it'll be the same. If there's a project and they're going to the Board of Adjustment and the Planning Commission, or just the Board of Adjustment, and also seeing us, if they're seeing us first, it could be that they end up going to the Board of Adjustment or the Planning Commission and they're required to change something that would in fact change the way that we would have looked at their project. Does the quasi-judicial process change how that gets tracked, and will projects come back to us if things change later on?
That's an excellent question, because it comes up a lot. So here's what the deal is, and here's what the UDO says. Before you can submit for a design alternate, you have to submit for one in conjunction with a pending plan, so a pending site plan or a pending subdivision plan. So you submit for that application with staff, and what happens is staff reviews it, and then they give you your first round of review comments. I'm sure most of you are familiar with that process. But something that's been added to the UDO for you guys is that they cannot request a design alternate from the Appearance Commission until they get those first round of review comments back. So that's one thing to keep in mind. The second thing is when they submit their application for design alternate, they have to submit their site plan or whatever their proposal is with their application. If approved, what the UDO says is that that approval is then almost incorporated or tied to that site plan, and it expires if and when that site plan approval expires. Now, if they change their site plan proposal, let's say they go to a further down the road and they change their plan such that it would then change as what you're alluding to, the design alternate you've already granted, then they would have to come back. And the reason, because of that, people asking sometimes before they were ready, is why they added in this requirement that you get your first round of review comments back before you go and ask for the design alternate. So that's a great question because that's very practical and it comes up often. And we try on the staff tries on the front side to prevent that from happening. And applicants are aware when they go in that this is tied to the site plan that's with their application when they're submitting, such that, if something drastic changes, then they have to go back. And it happens. I mean, you'll see people come back. Board of Adjustment has a case now that's coming back, I believe. So great question.
So you all are the ones who track that?
Yes. Yeah.
Okay.
Yes.
All right, thank you.
And Bradley and Daniel might want to talk on that too, because it's the things that you're hearing have to do with their department's review. All right, I'm 2 minutes over. I told you we could talk the whole time. We probably could talk for hours more about this. So I hope this is a good primer 101. There's certainly more things to talk about with legal quasi-judicial, but a lot of this we will also just work on it as we go. So, and now to the third part, the most important part is what is it you're hearing? So I appreciate your time and always email me with questions. You're always welcome to ask.
Well, thank you, Catherine and David. I think I've been hearing that we need a couple minutes of a break for the commission members. So if we could do, let's say 5 minutes, could we take a quick break and reconvene at 1:07? Does that work for everybody? Yeah. Okay. All right. Ready, break. I'd like to now introduce Daniel King and Bradley Kimbrell with Transportation Department to talk about design alternates.
All right. Well, thank you very much. Thank you, Catherine, for the first half of this with kind of all the legal stuff. And I appreciate actually where you left off, which was with the findings, because that's where I'd like to pick up from here, because I think it's important as we look at how this process works, that we all understand what the findings truly mean. And I think someone mentioned earlier that a lot of the board members are architects, landscape architects, civil engineers. And I think that'll be very helpful based on the makeup of this board, that these are the types of items that you'll be hearing. So if I'm too simplistic, let me know. If I get too technical, let me know. Feel free to ask questions along the way. I do want this to be an interactive opportunity to make sure that we answer any questions that you may have about what you will be hearing and the findings in order to grant the alternates that might come before you. So Bradley, actually, if you can scroll down just a little bit for me, I'm probably going to take the bulk of the speaking here, but Bradley's going to jump in when I either get something wrong or to talk about some of the technical pieces of things. But what's in front of you now, and can everybody see what Bradley's got up okay?
Yeah.
Great. I'm seeing a lot of nodding heads and thumbs up, so that's good. So these are the showings that are required. So this is the findings that are required in order to grant the design alternates that you'll be seeing. This particular section is specific to design alternates related to 8.3. So that's 8.32, 8.34, and 8.35. And those revolve, primarily around block perimeter, substreets, cross access, and we'll get into a little more detail about what all of those things mean and what the intent of those items within the code are. And I just want to reiterate some of what Catherine mentioned, is that it's very important that all four of these findings are met in order to grant the design alternates. The code is written very specifically that way, because each of these is very important and has a significant impact to why it's being granted or not granted. And so it starts out with meeting the intent of the sections. And as we get into the technical piece of what those sections mean, that'll be the opportunity to really kind of get into what that intent is. And I hope at that point, as we go through it, it will make a lot of sense, but that you guys will also ask questions along the way if you have them. The second one is a little more straightforward. It talks about not increasing congestion or compromising safety. Those are obviously things that we don't want to do within the city. So if someone's asking for something that further complicates those issues, there needs to be a really, really good reason why and how they're mitigating those issues so that they don't create those concerns. And then the third one, also pretty straightforward, talks about not conflicting with city projects. And so obviously if we've got a city project that's ongoing and somebody's asking for something different in that same vicinity, then that can be problematic for the ultimate implementation of those projects. And from a capital improvement standpoint, that becomes certainly an issue. And then the fourth one, and this is where things start to get a little subjective, and that's why this is going to a quasi-judicial process versus the administrative process that it used to go under. These start to get a little more subjective. And under the fourth item there, only one of the following has to apply in order for it to be granted, assuming all of those other 1 through 4 have been met. And so A, B, C, and D give you guys the ability to look subjectively at certain things, the physical environment being one of them, meaningful connectivity. And again, as we get into the technical pieces of things, I hope some of that intent and understanding will come through. Compliance not compatible with adjacent uses, And then the burden of compliance is not reasonable given the size of the site or the intensity of the development. And that one's there very specifically to capture when there are very small sites that might have to put what equates to a pretty large road through their site in order to comply with the standards. So if there's a relatively large, dense development, this one probably doesn't apply. But if there's a very small site that's being developed and there's going to be a lot of infrastructure improvements that are required for it, that would be one of the ways that they could show how that would not be appropriate in that case. So those are the findings for 8.3. And then Bradley, if you'll scroll down just a little bit, there's a slightly different set of findings for 8.4, 8.5, and the Raleigh Street Design Manual. And the Street Design Manual is where really the technical aspects of design live. The UDO is more form-based, has more planning guidance and information, although it does have some technical standards, but many of those technical standards are in the Street Design Manual itself. And this one, there's a few more findings that have to be met. And I actually won't go through all of those directly. Most of them are the same as what we just talked about. They do add that a professional engineer has to have been, designed the alternate, and that it won't adversely impact stormwater collection or conveyance. And so those are really the add-ons in this point. And then number 6 is where you then get the discretion of, one of the following. And it's a shorter list, but the first one, again, is the existing physical environment. And it gives you a couple of examples of what that might be. It's not an all-inclusive list, as it mentions, but those are some of the items. And then the burden of compliance not being reasonable given the size. And so that's the same as the last one above, and for the same reasons. The other thing I want to point out at this point is that as we rewrote these sections and ultimately came to the design alternates here, one of the other things we did as we went through 8.3 and 8.5, or 8.3, 8.4, and 8.5, is we looked at situations where the city was aware that there were constraints that would cause projects not to be able to meet the standard of the code. And so in that process, there were by right exemptions that were written into the code that did not originally exist, so that city staff would have the ability in those cases to use those by right exemptions to not require full compliance with the code. And so that's eliminated a lot of the cases that have had to go forward to these types of hearings. Hasn't eliminated everything, obviously, or we wouldn't have had to write this section into the code, to create this, but it should take care of the vast majority of things. So I mention it because what you'll probably see as you start seeing these design alternate requests come to you is one of two things. They will come as a developer who says, well, I don't really want to meet the code, so I'm going to go ask for a design alternate. And they still have the burden of meeting those findings, but that's why it's so important to evaluate each of those findings, because a lot of times it's really a matter of, it's easier for me to develop my site and not meet them than to meet them. So I'm just going to go ask for, a different way to design my site that doesn't meet the code. The other thing that you'll see is the unique sites that really truly do have a constraint that was either very difficult to codify or was just something that's so unique to the site that it was not something that was considered or thought of. And so just as you are evaluating these cases, I think that'll be helpful to look at and think about, is this a want or is this truly the constraint? And I think evaluating the findings and checking them off as you go through, and to Catherine's earlier point, being able to restate at the end, and that will help her very much also write the ultimate decision, stating why you either think that it does or does not meet the findings that are there. And to that point, that's one of the reasons that, and it will primarily be me and Bradley, although it may be some of our review staff as well who will be present at the meetings. But between the staff report and any questions that you may have for us, we can help provide you the information that will assist you in making those decisions in a fully informed manner. So at this point, I'll take a quick stop and see if anybody's got any specific questions on the findings or what they mean before we move on. All righty.
This is in the document. This is the packet that Catherine sent out to everybody. It's toward the end of the document. You can see that it's essentially the TC17 exchange that just came out.
Okay. So we can move on then. Bradley, let's move on to the code sections, and we can kind of talk about some of the standards. The code is pretty lengthy, and I don't think we have time in the hour that we have today to go over every single aspect of the code. So what we're going to focus on is we're going to try to kind of hit the highlights of what we regularly see come to the board for these requests. So really the items that are the ones most often coming forward. And it's a relatively short list, but there's a lot to unpack in each of those sections. There's block perimeter standards. Tied to that are substreet standards and cross-access standards. Driveway spacing, which Catherine mentioned earlier, is a big one, and that's one that we see a lot of. And then the last one, and I'll only touch on it really a little bit briefly, is backing movements within the public right-of-way. And what that one really comes down to is we primarily see that in the downtown area where sites have to provide some type of service availability for either trash pickup or move-ins or those types of things. And sites may or may not be large enough to allow for vehicles to enter and exit the site in a forward motion, which is what's required by the code. So we do see those requests for relief from that standard to allow a vehicle to back in or out, into the right-of-way in order to provide those types of services. The evaluation of that usually revolves mainly around safety concerns. And so in highly pedestrian areas, that's a larger concern. And usually there's some type of traffic analysis or at least some type of analysis of the vehicular and pedestrian movement in the area that would be required in order to demonstrate how they met that. And unless there's any questions on that one, I'm probably not going to go into a whole lot more detail there. And we can move on into the block perimeter and some of the access and network accessibility issues that we're going to talk about here. So moving into the block.
The reason I kind of paused here, Daniel, was because I know you mentioned about all the by right exemptions. And I know with this document is the TC6 exchange that went into play last end of 2019. And it just gives you an idea of the by right exemptions available.
Yeah, and I won't go through all of these specifically. I believe they're all in your packet as well. And so they're pretty comprehensive. They cover a lot of different possibilities of reasons why projects might not have to meet the exact standard of the code, specifically to block perimeter and to cross access. And one of them is a minimum site size before you're required to meet the standards. That really takes care of most of the issues that you would see where somebody would be arguing that the size or the density of the development didn't reach a level that should require the improvements. And so that's why the minimum site area is in there. And then most of the rest of them focus on some type of physical constraint, whether it be topography, whether it be adjacency to single family lots with single family homes on them, which, stubbing a street or creating a block that would dead end into the back of someone's home is obviously not desirable for the city or the homeowner or the developer of whatever lot is creating that street. So those are the types of things that you'll see in the exemptions. And like I said earlier, those really will catch the vast majority of what we're talking about, from block perimeter, cross access, and stub street standards, although there will be some occasions that they don't. What Bradley's now pulled up is some examples that are in the code. These are graphics that are there to kind of help define and explain what block perimeter really means. And what it really is it's simply a measurement along the face of the right-of-way, around the block that bounds whatever project is under development at any given time. And the reason that different lengths of blocks are allowed depending on the zoning really comes to how much accessibility and how many different ways in and out are appropriate given the density of a project. So a large single family neighborhood in suburban area of the city doesn't need as much direct connectivity as like the downtown core or more urban areas that have higher density uses, more commercial uses, and need more access and more of a network in order to create good connectivity and not create congestion and traffic concerns. And not that it's going to solve all of those, but the more roads, the more ways in and out and around, the more opportunity people have to avoid the higher congested areas, which is really what the intent of this comes down to, is giving people choices and ability to get around in multiple ways so that we don't concentrate all the traffic in one place. And Bradley, feel free to jump in.
No, Dan, the only thing I'd add is we often get caught up in thinking about block standards to emphasize the vehicular movements. But one thing that we have is within our public street standards is the allowance for pedestrian movements, obviously bicycles, the majority of our infrastructure. So as we start to think, okay, we're connecting cars with other cars, we're also creating the infrastructure that's protected for the public on bicycles and the pedestrian.
Yeah, and to that point, and thank you for that add on there, Bradley, the code also allows an extension of block perimeter when you create those additional pedestrian and bicycle connections. So one of the things that the code lets a developer do by right is if they add either an alley or a pedestrian connection between opposing block faces, to allow those pedestrians and the bicycles, other modes of transportation to circulate, that they get a 50% add-on to the allowable block perimeter. So it allows that block perimeter to be extended by 50%, when they provide that additional connectivity for those other forms. So it is not a pure vehicular prioritization. There definitely is some prioritization back to the pedestrian and the bicycle user as well. So great point there, Bradley. Thanks for pointing that out. So yeah, actually, this is a good one, Bradley. So this kind of starts to get a little bit of the balance between block perimeter and some of the stub street standards that you'll see. One of the things that's also required in addition to just the block perimeter is that undeveloped parcels are stubbed to in order to create those future connections for future block perimeter compliance. And this graphic shows just some of the ways that can be accomplished. And there are limitations on this as well with the measurement. Half of the allowable block can be on the subject parcel. And the reason we limit it to half is so that when an adjacent parcel comes in for development later, they can complete the block without undue burden to their development by having to put a street in right on the property line or hinder their ability to utilize their property because of the block perimeter standards. So the stub streets to undeveloped parcels and that limitation of what that block measurement is are important to this portion of the code. So that,
I guess, is a good kind of check in with the group.
Yeah.
Questions before we go on to cross access and site spacing, driveway spacing.
Okay. And one thing we are going to do too, and when we get to that point, I'm hoping it'll start eliciting some questions and create some interaction here, is we're going to have, as we kind of get through some of these standards, we are going to have an example we're going to put up on the screen of a site that's in Raleigh that we can actually point out some of what this really looks like on the ground. So I think that will also be helpful. As we move down though into cross access, again, cross access, very similar to block perimeter, is all about creating a good network of connectivity and also limiting, particularly on our high traffic or heavier traveled corridors, also limiting the number of driveway access points that might be attached to those. And the access management that creates is very important, because every time you have a driveway, particularly on a busy corridor, you create a decision point and a conflict point that creates ultimately safety concerns. So if you drive along a busy road and you see driveway, every time you are coming up on those driveways looking for vehicles that might be coming in, there's additional conflict points there. And sometimes those driveways even conflict with each other with how vehicles are moving in and out of them. And it just creates a more unsafe condition. And so that gets into what the driveway spacing, as well as what the cross access standards are meant to handle, is creating the ability for driveways to be shared between properties from an access standpoint, but still not limit the ability for those properties to be utilized and developed by that access, while creating a safe connection to those roadways. And that will be really a lot easier to explain when we do get to the example we're going to put up. So does anybody have any specific questions on driveway spacing or cross access before we move on to that example? And Bradley, do you have anything more to add before we move on to that?
No, I feel like we should have probably put in a diagram or two, because when I look at this standard, it's pretty dry.
Yep.
I was just thinking of Wade Avenue, and that being a good example of why you need cross access.
It's an excellent example of why you need cross access. And actually, the example we're going to give is not on Wade Avenue, it's out on Falls of News, so also a pretty large corridor. But what we're going to show you is hopefully some stuff that is good access management and actually has some good spacing standards to counter what kind of Wade Avenue looks like.
I know we're going to use terms like conflict points, and I just don't know what everybody's comfort level there is in terms like that. I just did a quick Google search, and I'm not going to bore you with everything, but it's one of these. It's, you start to look at diagrams where the vehicles, as they maneuver, going at intersections and driveways. That's what we're talking about with conflict points. So we probably won't belabor you with this too much. Well, we can start to talk about it in our examples. But when we say conflict points, we're talking about all these dots. Train maneuvers overlap.
Yep. And what all those dots really represent is they represent an opportunity where vehicles can actually come into contact with each other and or pedestrians, which is not shown in this graphic, but that's the other piece of that puzzle, is that we also have sidewalks, crosswalks, we have bicycles that use these corridors as well. And so every time there's a conflict point there's an opportunity for a collision, whether it be vehicle to vehicle or vehicle to pedestrian. And those are the types of things that we're trying to limit from a safety standpoint while still providing good connectivity and access. Thanks, Bradley. That's a good graphic.
Yeah, on our outline, we talked about going to the spacing standard in the street design manual. Is you still good with that?
Yeah, no, that's great. So as we talk about driveway spacing, there's a couple of different things that we get into from a spacing standpoint. One is spacing of driveways from intersections of streets, and the other is spacing of driveways from other driveways. So the graphic that's here addresses mostly spacing to other public street intersections. And so these spacings are shown, and you'll see some different numbers in there. And what those numbers really represent is based on what type of movement is happening at the intersection as you're approaching the driveway, really drives a lot of how far that driveway should be from the intersection to create a safe situation. And so if you're making a right-hand turn at an intersection and approaching a driveway that you're coming up to that's also on the right-hand side, you have pretty free movement to continue moving there unless the driveway itself is blocked. But even if so, you also have a lot of visibility through the intersection, so people see that you're stopped there before there's a conflict point. Contrasting that, if you're making a left-hand turn through an intersection and approaching a driveway that's on the left side, it often needs to be further away from the intersection to allow for vehicles to stack and queue before making the turn, because there may be oncoming traffic that's limiting their ability to make that movement freely. So that's really what this kind of represents. And you'll see on here, there's different numbers, and it depends on whether it's a major street to major street intersection, or a minor street to a minor street, or a major street to a minor street intersection. And I won't go into all of those specific details, but based on all of those different parameters, there are different spacing requirements that need to be met from intersections. There is recognition within the UDO that if you don't have enough property frontage to meet that standard, that we're not going to deny all access to any site. So if there's not an available cross-access opportunity, and there's not the ability to meet the full standard, we still would allow a driveway, because we obviously want the property to be able to be used and to be able to be accessed. But if there is a safer alternative that is available that does meet the standards, that would be what would be the expectation. And then driveway to driveway spacing gets a little dry in here again, because it's just simply that if the roadway is over a certain width or type of roadway, there's a 200-foot spacing, or under a certain width, there's a 200 spacing, and over a certain width, there's a 300-foot spacing. And Bradley's pointing out those two numbers there. So those would be the numbers that you'll typically hear, either a 200-foot spacing or a 300-foot spacing, and it's just driven by the size of the roadway that's being accessed there. Obviously, a less traveled, smaller roadway can accommodate more access points than a higher traveled, larger roadway can. And so I'll throw out there one more time if there's any questions before we move on to examples. All right. You ready to get us out there on Falls and Moose, Bradley?
This is definitely more visually appealing.
Yeah. So this is Falls of News Road, just kind of south and west of 540. This is actually the Lifetime Fitness that's up there, that's highlighted in red. If anybody's familiar with the area or the gym there, this actually did come in pre-UDO for development, and I point that out for a couple of reasons. We very intentionally picked a site that wasn't one that you were likely to see, because we didn't want to have any concern with ex parte communication prior to any hearing that you might have by picking a site that might be vacant or that might be redeveloped at some point in the near future and might seek a design alternate. So we picked one that's already on the ground that had some good examples of how driveway spacing can be met well, how cross access and a little perimeter here as well, knowing that because it was pre-UDO, it may not fully meet every standard, but there are some good examples and some good visuals here. So we'll start kind of with the driveways on Falls of News there. You can see two large driveways that are there that access the site as a whole. Falls of News is a pretty heavily traveled corridor, large roadway, requires a 300-foot spacing. You can see that these driveways, meet that standard. They're more than 300 feet apart. In addition to the fact that they're more than 300 apart from each other, they're also 300 feet apart from the opposing driveways or adjacent driveways on other parcels. And so that's important as well, because it's not just about the driveways on any one parcel, it's about the driveways along the corridor as a whole. And that's what gets back into the cross access, and I'll kind of jump to that piece of it as we talk about it. And you can see a couple of locations here where there is existing cross access. Bradley's going to highlight them for you here in green. And then there's some other areas, there are some cross access opportunities that may not connect today, but are set up for future connections in order to help keep the corridor moving. And sometimes cross access is used to limit the number of driveways that are along a corridor. And sometimes it's just simply used so that if someone's traveling from one use to another along the same corridor, that they may not have to actually go out onto the roadway. So, good examples of that are scenarios where you might have an office next to a restaurant where people might want to go across and eat, or even a gas station next to a restaurant along a corridor. If there's not connectivity between the two of them, somebody might have to actually get back out onto the major roadway just to go next door from one place to another. So cross access serves a number of purposes in that regard.
Daniel?
Yep.
Quick question. The Lifetime Place Road, is that cross access or is that its own way out?
So that is actually, it's actually a public street there. So it serves a lot of the same function from a connectivity standpoint. But in this case, it is a public street. And I'm glad you asked that particular question, because if this had come in after the UDO, not only would that portion have been public, but the portion that Bradley's highlighting now across the backside of that parcel would have also likely been a public street. And then in this case, because 540 happens to be there, there's a by right exemption in the code that would not require them to stub anything to the north for eventual connectivity. But if you imagine for a moment that 540 was not there, or this was a site that wasn't adjacent to a highway, there might be another roadway running north and south, as Bradley's drawing now, to start to create that block perimeter pattern that creates that connective grid. Any questions about that piece of things? But like, scroll up there to the parcels on the south side of Falls. Let's point out there's some good cross access on that side as well that we can point out. You can see that the driveways mostly along this section are pretty nicely spaced. And one of the things that really allows that to occur is the connectivity between these buildings. And so, again, Bradley's going to kind of draw some areas that are either existing connections or are set up for future connections to kind of help mitigate the direct access to this highly traveled roadway to help keep everything safe and moving well. And so the parcel kind of to the east, next to the brown roof there, you can see there's probably an underdeveloped parcel there. It looks like probably a single family house today, or maybe a small office that could easily redevelop into something more. And the parcels on each side of it have stub cross access to that parcel already. So when that comes in for redevelopment, we won't need to necessarily be looking at a new driveway connection to Falls of Noose that could create that additional conflict point, an additional point for a safety concern. They would have access through the cross access going either to the east or the west. And then the same thing exists kind of through this whole area here. Yeah, as you see all of the different green marks that Bradley's put there that show how these are interconnected.
Make sure that we covered a lot in a very short amount of time. And I just want to point out the value added when we look at a busy corridor such as Falls of Noose or 401 or Linwood Avenue, Wade Avenue. I'm sure there's a half a dozen more that we could rattle off. The value of spacing the driveways is critical. That's why that's one of the number one things that we look at on the site side. Avoiding stacking as many conflict points in close proximity to one another. And then the value added of cross access, as Daniel said, see if this is a Lifetime Fitness. Maybe there's a coffee shop right here. Instead of me coming out, turning right, merging onto Falls of Noose, then slowing back down, turning right into the coffee shop, that adds value of going out to the cross access. This could be an apartment complex, and this could be a gas station. Same exact concept. Folks are swinging through to get their morning coffee or biscuit and heading out the door. Again, trying to reduce the number of trips, vehicles coming in and out of Falls of Noose by way of other connections. Cross access and our block perimeter standards allow us to do that.
Yep, and those are all great points, Bradley. Thanks for the addition there. So I also want to just kind of reiterate, we talked earlier about what the findings were and how those are evaluated. And then just want to offer up as well that Bradley and his team and I will be available at these meetings regularly, both from the perspective of creating a staff report that will give you some level of information on what you're seeing, but also to be there to answer any questions that anybody has as the proceedings occur. So we're there both as an expert witness for the technical standards, but also as an expert witness as to the intent of the code. So as you evaluate, those standards and those findings, specifically the intent findings, we can kind of help give you the information to help you make those decisions. Again, going back to Catherine's earlier point, we're not able to be there to speak from an opinion of you should or shouldn't approve this, but we are there to be able to help give you technical information about the intent and technical information about any impacts the design alternates might have to congestion, to safety, and to those types of things. So that's the role that we'll be playing in those meetings to help provide that information.
Daniel, this might be a little off subject, but just looking at the parcel to the south that we're just looking at, the possible redevelopment there, there's a couple different locations of cross access on either side. I mean, are we basically setting up a requirement for that future development if that is where they need to provide their cross access? Or, based on the new UDO, if they need to be tight to the road, or if they want to put their building tight to the road with parking behind, I mean, we've got a cross access that goes into the side of their building. I'm wondering how that works, and is that the kind of stuff we're going to see?
So it is very likely the type of things that you actually will see in those scenarios. You may see a situation where the build to creates a situation where a building needs to be built within a certain dimension away from the right of way might conflict with an existing cross access stub. And I think those are, to your point, probably exactly the type of things that you might see come to you. And that'll be an analysis of, which standard can be met and which one can't. And there may be a scenario where they need to shift their building to make it function with what's available, or there may be a scenario where a code provision conflicts with another that you may analyze and say, okay, given this code provision, they can't meet this other one, and so there may be some of that decision making that you have to do as you look at that. I don't know if that answered your question fully or not.
Yeah, I think so. I just kind of going along with that. Yeah, if for some reason a building takes the whole width of that site and they can't provide that cross access, it comes in front of us. I was just wondering if we would have the ability to suggest alternate cross access, or if you would come before us and with suggestions on other locations that would be suggested locations for cross access, or how that works with an existing parcel. You could make those modifications.
Sure.
Into an existing parcel.
Obviously, if the parcel next door is vacant, it's a pretty easy scenario. They can provide a cross access offer wherever it works for their parcel. If there's existing cross access available on an adjacent parcel and this parcel is being developed, it becomes a little more challenging because we can't make them go to the neighboring property and say, hey, you have to move your cross access to accommodate where we need it. But they could still go to that neighbor and ask, hey, if we come in and move this cross access for you, would you accommodate that move? And sometimes the neighbor will do that and sometimes they won't. One of the things that I'll throw out to that point, though, is that I don't think any of the frontage standards or the build to standards don't allow at all for access from the roadway. So if they could put a driveway in, if they're arguing that, the only way we can access our site is by putting a driveway here, then they can make the same footprint work in its given location. So that would be kind of a balance of some of what you need to be looking at there.
Thank you.
Mm-hmm. So I know that was, to Bradley's earlier point, that was a lot of information in a relatively short time. We're also approaching the end of our second hour, so I don't want to just keep talking, but I do want to answer any additional questions that there are. So we're pretty much done with what we had set for presentation, but are happy to continue to answer questions if there are more.
This is Jake. I'm not sure if this is a question for Lee or Carter or for you all, but which meeting will be our first quasi-judicial meeting? And do we have any cases lined up for that meeting?
Yeah, our first meeting with a potential alternate would be October 1st, and that would correspond to their 60-day submittal deadline had passed a little while ago. So we're looking at one for the October 1st and maybe two for the November 5th meeting. So we'll hit the ground running.
Thank you.
Anybody else? All right. Well, thank you, Daniel and Bradley. It was a lot of information, and I know it took a lot of time to put that together for us. So thank you, and hopefully we'll observe it after the first few meetings. I'm sure it'll be like second nature, and it won't be so difficult for us. I'm excited to review, block standards, because I think it has a pretty significant impact in how the city develops and pedestrian experience, especially. So with that, if no one has anything else, I think we're going to close out the meeting. All right. We'll approve our meeting minutes from our August 20th meeting at our September 3rd meeting, so we don't need to do that today. And with that, we are formally adjourned. Thanks, everybody, for showing up and for participating and absorbing all of that.
All right, everyone.
Thank you. Bye-bye.
Everyone.
Thanks, everyone.
Oh, thank you.
A lot.
Thanks.
Thanks.